दिखाइएगा तो
May I submit, my lord? Just I would like to refer the provision of 17B, your lordship. I have filed affidavit in as per rules provided 17B. May I read, your lordship? 17B. What is the concept of 17B? To that effect, I filed affidavit before the CJIT, your lordship. My lord.
17B का एफिडेविट सीजीआईटी के सामने कैसे फाइल होगा? वकील साहब, थोड़ा कानून तो हमें समझाइए।
17B in fact जो कंसेप्ट दिया है सर उसमें।
नहीं, कंसेप्ट नहीं। 17B की कंप्लायंस किस स्टेज पर होती है?
हाई कोर्ट सुप्रीम कोर्ट में है सर।
नहीं, हमें नहीं मालूम हाई कोर्ट सुप्रीम कोर्ट में।
मैं रेडी, your lordship।
उसका एफिडेविट सीजीआईटी में कैसे फाइल हो जाएगा?
एफिडेविट उसका तो यहाँ भी फाइल है, बट जो कंसेप्ट है कि मैं कोई भी
नहीं होता है,
कोई एस्टेब्लिशमेंट में मैंने काम नहीं किया, क्योंकि मैंने मजदूरी तो कर सकता है सर, बट गेनफुल का नहीं है उसमें।
आपके दाएं बाएं भागने से कुछ काम नहीं होगा।
जजमेंट
पढ़िए 2013 का 10 जजमेंट पढ़िएगा
जी, पैरा नंबर 38 में करनी।
पैरा नंबर 38
मैं रीड, योर लॉर्डशिप।
एक मिनट रुकिएगा। 38, yes.
The propositions which can be culled out from the aforementioned judgment are, in cases of wrongful termination of services, restatement with continuity of service and back wages is the normal rule. The aforesaid rule is subject to a rider that while deciding the issue of back wages, the adjudicating authority or the court may take into consideration the length of service of the employee, workman, the tenure of the nature of the misconduct, if any found proved against the employee, workman, the financial condition of the employer and similar of the factors. Next, ordinarily an employee or workman whose services are terminated and who is desirous for getting back wages is required to either plead or at least make a statement before the adjudicating authority or court or first instance that she was not gainfully employed or was employed on lesser wages. What I filed before the CJIT. If employer wants to avoid payment of full wages, then it has to plead and also lead cogent evidence to prove that the employee workman was gainfully employed and was getting wages equal to the wages.
स्टेटमेंट देखें जी, स्टेटमेंट पढ़े आपका P1 था ना?
हाँ जी, एफिडेविट हमारा।
हाँ, एफिडेविट था
जी।
उसका पेज पैरा 10 बताया था आपने।
9 सर।
9, चलिए 9 देख लेते हैं। हाँ, पढ़िए 9।
यह कि सर्विस बर्खास्त होने से लेकर आज दिनांक तक मेरा करीब 2 लाख रुपए मुकदमे में खर्च हो गया और प्रत्येक पीसी में मैं आने का प्रयास किया हूँ, जिस वजह से मैंने अच्छे से मजदूरी भी नहीं कर पाया। इस प्रकार मैं किसी संस्था या किसी बर्खास्तगी के बाद नौकरी नहीं किया, क्योंकि मौत नहीं आई इसलिए जिंदा हूँ। अतः माननीय न्यायालय से निवेदन है कि मुझे फुल वेजेस संपूर्ण दिलवाया जाए।
ये कहाँ पढ़ दिया आपने?
ये हमारा जो स्टेटमेंट है सर, इसमें P1 में हमारी पिटीशन का।
अरे भाई P1 में आपने पैरा 9 के बाद में पैरा 10 कंटिन्यूएशन में कहाँ है ये? गया कहाँ पे? पेज सारे उल्टे सीधे लगाए हुए हैं।
मतलब that handwritten passage is cross examination मतलब।
बात नौकरी नहीं की, क्योंकि मौत नहीं आई तो जिंदा हूँ।
ये पूरा कंप्लीट हो गया, फिर सत्यापन आ गया सर इसका। तो ये कोई एस्टेब्लिशमेंट में गेनफुली में नहीं किया, इसीलिए मैं 17 में पढ़ा रहा था कि एस्टेब्लिशमेंट लिखा है कोई उतना इक्वल टू गेनफुल में है, देन और ये नहीं देना चाहेंगे, देना है तो दीजिए। ड्यूटी ऑफ द एम्प्लॉयर टू प्लीड।
अब 17 भी पढ़िए
जी। तो सर इसमें हमारा 17 भी हम क्या, आई एम गेटिंग नथिंग योर लॉर्डशिप, क्योंकि वो सुपर इन्वेट हो गया था तो उसमें कुछ भी नहीं मिला है हमको अभी तक। पेमेंट ऑफ फुल वेजेस टू वर्कमैन डिपेंडेंसी इन हायर कास्ट, वेयर इन एनी केस अ लेबर कोर्ट, ट्राइब्यूनल और नेशनल ट्रिब्यूनल बाय इट्स अवार्ड डायरेक्ट्स reinstatement of any workman and the employer prefers any proceedings against such award in high court or the supreme court, the employer shall be liable to pay such workman during the period of pendency of such proceedings in the high court or the supreme court full wages last drawn by him, inclusive of any maintenance allowance admissible to him under any rule, if the workman had not been employed in any establishment during such period and an affidavit by such workman had been filed to that effect in such the establishment similar to the my payment your lord's salary.
अच्छा, ठीक।
So then my lord, this provision has what happened my lord, circumstance is this, I was superannuated by filing of this writ petition, so I am now getting nothing your lordship, nothing has been found my lord. Then I would like to submit my lord that judgment 38.4, the cases in which the labor court tribunal exercises power under section 11A. The Industrial Dispute 1947 finds that even though the inquiry held against the employee workman is consistent with the rule of natural justice, certified standing orders, if any but hold that the punishment was disproportionate to the misconduct found proved, then it will have the discretion not to award full wages. However, if the labor tribunal finds that the employee or the workman is not at all guilty of any misconduct, or the employer had hoisted a false charge, then there will be ample justification for award of full. In my case, my lord, inquiry was found to be vitiated because natural justice there is also bias. Because before so cause notice, I filed a complaint under section 420 before the judicial magistrate first class against the manager itself. As soon as he received summons, they issued me so called notice. I have written my statement claim and each and everything. There is this is not denied, lordship. Also this is a case of victimization. I pleaded that in my affidavit and my statement claim also. Para number 2 and 3. Para number 3686. In a number of cases, the superior court have interfered with the award or primary adjudicating authority on the premises that falsification of litigation has been long time, ignoring that the majority of the cases the party are not responsible for such delay. Lack of infrastructure and manpower is the principal cause of delay in the disposal of cases. For these litigants cannot be blamed or penalized. It would be amount to grave injustice to an employee or workman if he is denied back wages simply because there is long lapse of time between the termination of his service and finality given to these cases. The employer in an advantageous position vis-a-vis the employee or workman, he can avail the service of best legal brain for prolonging the agony of the sufferer. The employee or workman who can ill afford the luxury of spending money and liar with certain amount of fame. Therefore, in such cases, it would be prudent to adopt the court's suggestions. This is Hindustan 10 works. This is a judgment of three benches, Your Lordship. That has been relied in this
Three
case.
benches मतलब?
Three judgment of Honourable Apex Court, which judgment has been relied in this case.
Three judges.
Three judges. Continuity of service is a normal rule, Your Lordship. If inquiry is vitiated and workman is not blamed, Your Lordship. So that's why I filed, my lord. What happened, my lord? 2 increment has been withdrawn. Even, my lord, there was the so-called notice, and I also played a victimization. So then, my lord, learned CJIT ought to have granted full back wages and, my lord, full, my lord, setting aside the dismissal order. Your Lordship.
Anything else?
Merely, my lord, what happened in this case? Management has directed to given an opportunity to prove misconduct. Then I filed this affidavit for the purpose of, my lord, I was not gainfully employed. Then in my affidavit, they have cross-examined.
हाँ.
Then, my lord,
और कहाँ होता है क्रॉस एग्जामिनेशन?
वो उसी में, और they have
तो बोला इन माय एफिडेविट, तो क्रॉस एग्जामिनेशन क्या दूसरे के एफिडेविट पे होता है क्या?
जस्ट मैं बताना चाह रहा हूं, मेरा जो पर्पस एफिडेविट का था कि ट्रिब्यूनल में एफिडेविट,
हाँ,
दे डिड नॉट एड्यूस एनी एविडेंस।
क्रॉस एग्जामिनेशन में क्या आया
जी, उसमें ये बोला कि 10 दिन के ज्यादा हम उसमें वो थे सर, जबकि हमारी पूरी वो है, हमारा एफिडेविट है, सो काज में हमने डिनाई किया है और पूरी तरह से हैबिटेटेड। जब इंक्वायरी हो गई तो इट वाज द मैनेजमेंट टू प्रोड्यूस इट्स एविडेंस, और यही सीजीआईटी ने बोला कि आप अपना प्रूफ करिए केस। तो दे डिड नॉट फाइल एनी डॉक्यूमेंट, दे डिड नॉट प्रूफ एनी एड्यूसिंग बाय एनी एविडेंस। और मेरे एफिडेविट में उन्होंने क्रॉस एग्जाम करके ये बुलवा लिया कि हाँ 10 दिन से ज्यादा हम एब्सेंट थे, ये आया सर। तो दे आर टेकिंग एडवांटेज दैट।
ठीक,
तो उसमें भी सर यदि ये भी हो जाए,
बुलवा लिया आपसे, गन पॉइंट पे बुलवा लिया गया?
नहीं, मतलब ये उसमें जो बोला उसमें बस उतना ही इनका जो वो है, इतना ही वो है। दे डिड नॉट फाइल एनी एफिडेविट, दे डिड नॉट फाइल एनी एविडेंस, और ट्रिब्यूनल ने पूरी तरह से आया सर। इन फैक्ट दे डिड नॉट प्रूफ मिसकंडक्ट, इवन अपॉर्चुनिटी वाज गिवन, लॉर्डशिप। And
Yes, बस
Paragraph 9. There are 2 charges against the petitioner, my lord. One that is habitual absenteeism, and the second one, absenteeism for more than 10 days. Now in his cross-examination, he admits he was absent for more days. No leave application was given, nothing. Therefore, in paragraph 9 of the award, your lordship will find that the learned tribunal interfered on the question of, held that one charge is not proved and one charge proved, my lord.
which paragraph 9?
Paragraph 9 of the award, my lord. Just, my lord. Read through, my lord. I'll just
Though management has not reduced
the evidence, it has come on the evidence. The management has not reduced the evidence about the charges against its cross-examination clause 26.320 unauthorized absence more than 10 days is established. The evidence of management did not disclose absence of workmen. Therefore, charge of habitual absenteeism under section 26.24 cannot be proved under these charges. The clause is proved against the workman. For the reason, I record my finding in fund number 1, charges under clause 26.30 is proved, charge under 26.24 not proved, my lord.
ठीक.
Then the learned tribunal goes on the question of back wages, my lord. My learned friend had also cited the judgment of Deepali Gundu. Now, if your lordship will see, Deepali Gundu is a case of unlawful termination, my lord. Here, and after the inquiry, it was terminated. Now, the learned tribunal has only interfered on the question of proportionality, my lord. Not that I have not been able to substantiate charges or not, my lord. If the charges to prove that judgment, the tribunal is rightly held not applicable, my lord.
These petitions are filed by the workmen and the management respectively, being aggrieved of award dated 27th August 2014, passed by learned Central Government Industrial Tribunal, cum Labour Court, Jabalpur, in case number CGIT/R/174/99. Full stop. Next paragraph. Learned Counsel for the workmen is aggrieved of the fact that learned tribunal has denied him 50% back wages and has ordered for his reinstatement with 50% back wages only. Full stop. The reading para 9 of his affidavit, which was filed before the industrial court, it is submitted that workman had categorically deposed in para 9 of his affidavit that para 8 of the affidavit, in para 9 of the affidavit, that he had to spend about 2 lakh rupees in the litigation from the date of his termination. Full stop. He makes an attempt to appear on each date before the court, as a result of which he is not able to perform his duties properly. Full stop. And thereafter he has said that because of the aforesaid condition, he could not work in any establishment. Full stop. Then he stated that since he did not meet his end, comma, he is alive, therefore he be given order of grant of reinstatement with full back wages. Next para. Reliance is placed on the judgments of Supreme Court in case of Deepali Gundu Survase versus Kranti Junior Adhyapak Mahavidyalaya (D.Ed.) and others, 2013 का 10 SCC 324 wherein reading para 38 of the judgment, it is pointed out that since petitioner was not employed in any establishment and onus was to be discharged by the employer, that petitioner was gainfully employed, denial of back wages is assailed. Next para. Shri Anup Nair, learned counsel for the respondents, in his turn submits that they are challenging the finding of the tribunal substituting punishment of termination as was inflicted on the workman by the employer with stoppage of two increments. Two increments with cumulative effect.
Cumulative. Yeah.
With cumulative effect. Whereas if there was any defect in the departmental inquiry, then matter should have been remitted back to the employer for conducting proper inquiry or for deciding the quantum of punishment. Next para. After hearing learned counsel for the parties and going through the record, especially the provisions as referred by Shri Ram Sufal Verma as contained in section 17-B of the Industrial Disputes Act 1947, this act does not define establishment, full stop. Thus, petitioner's contention that as per the law laid down in case of Deepali Gundu Survase, since petitioner was not employed in any establishment of the like nature, he will be deemed to be unemployed is not made out, especially in terms of the averments made by him in para 9 of his affidavit, which is dated 10 June 2013, which is in fact a tacit admission of his employment during the period of termination. Next para. It is true that employment in terms of the paragraph 38.3 will entitle him to some back wages as he was not gainfully employed and was getting wages equal to the wages he/she was drawing prior to the termination of service, but it cannot be set full stop. Thus, as far as issue of grant of full back wages is concerned, in view of the admission made in para 9 of the affidavit by the petitioner himself, case for full back wages is not made out. Next para. In fact, in case of Deepali Gundu Survase, in para 38.4, it is noted as under, within inverted commas, 38.4. The cases in which the Labour Court / Industrial Tribunal exercises power under section 11-A of the Industrial Disputes Act, 1947, and finds that even though the inquiry held against the employee / workman is consistent with the rules of natural justice and or certified standing orders, if any, but holds that the punishment was disproportionate to the misconduct found, proved, then it will have the discretion not to award full back wages, full stop. However, if the Labour Court / Industrial Court finds that the employee or workman is not at all guilty of any misconduct or that the employer had foisted a false charge, then there will be ample justification for award of full back wages, full stop. Next para. Back wages, full stop, inverted commas close. In para 38.5, Honourable Supreme Court has observed as under, within inverted commas, 38.5 -- उसके आगे लिखिएगा, the courts must always keep in view that in the cases of wrongful / illegal termination of service, the wrongdoer is the employer and the sufferer is the employee / workman, and there is no justification to give a premium to the employer of his wrongdoings by relieving him of the burden to pay to the employee / workman his dues in the form of full back wages, full stop, inverted commas close. Next para. When these aspects are taken into consideration, then finding recorded by the learned tribunal in para 9 of the award that employer could not prove the aspect of willful absence but would prove the aspect of absence for more than 10 days as has been admitted by the workman, which is violation of clause 26.30 of standing orders, and held that charge of habitual absence under clause 26.24 of standing orders is not made out, is a just and proper finding. Next paragraph. That finding does not call for any interference, as it is based on the evidence as was given by the employee himself and admitted in his cross-examination. Next paragraph. As far as grant of back wages is concerned, comma, in terms of paragraph 38.3 of Deepali Gundu Survase, since there is no blanket or clear denial of not being gainfully employed at all, comma, exercise of discretion to award 50% back wages in along with reinstatement cannot be faulted with, full stop. Next paragraph. As far as substitution of wisdom of the tribunal to substitute the punishment awarded by the disciplinary authority is concerned, comma, when this is examined in terms of the paragraph 38.5 of the judgment of Deepali Gundu Survase, comma, it is evident that employee being in a continuous disadvantageous position and remanding the matter back to the employer would not have cured that disability which is suffered by an employee, and with a view to curtail prolongation of disciplinary proceedings, if learned tribunal substituted the punishment looking to the gravity of the misconduct admitted by the workman leading to violation of clause 26.30 of the standing orders, comma, especially looking to the fact that the order of termination was of the year 1997.
जी.
सही fact
15-12 से तब.
and award was passed on 27th day of August 2014, that is almost after 17 years, comma, substitution of the punishment cannot be said to be arbitrary or illegal, full stop. Thus, substitution of disproportionate punishment with an appropriate punishment under the facts and circumstances cannot be faulted with. Thus, in the opinion of this court, the award having been passed in a comprehensive, balanced manner cannot be faulted with to cause interference in the supervisory jurisdiction of this court. Both the petitions fail and are dismissed.